Hearing. I'll get to that in just a second. Confirmation in this case is set for a week from today, with trial scheduled to start the following week. This case had originally been set for trial. We all appeared at confirmation. As I recall, that confirmation hearing, Mr. Cover, on behalf of his clients, had requested a continuance. That was granted. One of the bases for the continuance was that his client, if memory serves, Debbie Lattin, wished to seek advice from other counsel. I had put on the record before that request was made my concern that I had this thought about in this case about the inherent difficulties of a single attorney representing two co-defendants in a case. And just for example, and just in thinking about this more, and again, this is just an example, I'm not saying this is going to happen, but if the evidence develops that one of the Lattins has more or less responsibility than the others, I know what the general defense is, that there was no animal cruelty in the first place, but if there was a division of responsibility for care of the animals, that would put could put Mr. Cover in a position of, well, client A is not necessarily responsible for the goats, which could be construed as pointing the finger at client B, which is an extremely awkward position for him to be in when he's the attorney for both of those clients. And so the state wished to have this resolved prior to trial with regard to who in fact is representing each Lattin, or if Mr. Cover is going to remain the attorney for both. And if that's the case, I would like an acknowledgement from Mr. Cover that he has had that discussion with regard to the rule of professional conduct 1.7, which is the general conflict of interest rule. He had a discussion with both of his clients on this, and they're willing to waive any complaint or issue with regard to conflict of interest and go forward, both of them together at trial with him as their lawyer, or if there's a new attorney going to come on board and join or represent one of the Lattins. And so I think that's the only thing we're on here for today. And if I have incorrectly stated any of the background leading up to today, I would invite either counsel to correct me, but Mr. Cover, I would turn to you. Where are we with regard to the representation issue, if I've laid that out?
Everything sounds correct that you said, Your Honor. I have put on file with the court a knowing waiver that's been signed by Carolyn Lattin, signed by Debbie Lattin, and also by myself, outlining not only the entirety of RPC 1.7, but also describing the nature of the advice that I have given them. I've served that copy on the state, so I believe, unless Mr. Lippert has some objection to the waiver that I provided, I think that we can put this matter to rest. They will not be presenting any defense, and I will not be presenting any defense in which one of my defendants issues a claim against the other, and all the other requirements of RPC 1.7. And the only other thing that I would ask today is if we could have a little bit of coordination on the next inspection of the goats. Mr. Lippert approached me a few weeks ago regarding an issue that the people at the animal rescue wanted to pursue a castration of some of the bucklings. We have vet reports on the record that indicate that would be a very dangerous procedure at these goats' age. So we've attempted to coordinate a date. Don't have that yet, but just wondering if we have any movement on that issue. And with that, I rest, Your Honor.
And then, and I haven't, let's see, has that been filed in the, oh, way there it is right there, November 20th. And so, Mr. Lippert, I'm looking at this for the first time. Did you get a chance to review the waiver?
I did, Your Honor.
Okay. Do you have any additional comment on that issue?
I don't.
Okay.
I'm not sure it solves the problem, but it's as close as we can get at this juncture.
And so, and then I'm just going to, your clients, and if I remember right, and I apologize if I'm wrong, you're Debbie Lattin, is that correct, to my left? And then you're Carolyn Lattin? And you reviewed this waiver with Mr. Cover, and he answered any questions you may have about potential conflict of interest in this case?
We read and signed it, good.
Okay, and you're prepared to go forward, both of you together with him as your attorney?
Good.
Okay. Okay, we'll be back here a week from today for confirmation. With regard to the issue that you just came up, I'm not really, I would encourage council to work with each other. I'm not, none of that's been briefed. I'm not gonna just kind of fly by this.
I don't think it's an appropriate topic for this
Right.
forum. Frankly, the state is not in control of the goats, no own the goats. They're in the care of Hooked Animal Rescue. Hooked Animal Rescue made a request. I passed that on to Mr. Cover, who passed it on to the Lattins, and they object or whatever, and that's fine. But that's not really a matter for the court that I can even see at this point. So it's not between the state and Mr. Cover. It's between Mr. Cover and Hooked Animal Rescue, or the Lattins and Hooked Animal Rescue through their attorney, as far as I'm concerned.
And then Mr. Cover, anything?
Your Honor, the reason that it's a matter for this court is because this case started as a civil motion for a petition for the return of the livestock. That petition is right today. It has to do with the ongoing care of the animals. And I would just remind the court that we have significant evidence of neglect on the part of Hooked Animal Rescue. And they are the custodians of the state's evidence. So if Mr. Lippert is saying that we can call Mr. Kalsa counsel for, Hooked Animal Rescue and somehow compel him to participate in this criminal process, that would please me, but I think you've already ruled at a previous hearing that Hooked Animal Rescue is not a party to this proceeding, and so I'm left to coordinate with the state.
Well, they're not a party to the proceeding, and if, maybe there's a communication gap, then maybe you could help facilitate communication between the Lattins and the Hooked Animal Rescue. I don't know, but
That's fine, Your Honor. I have no problem. I have no problem with that.
Okay.
And I will do what I can. At this point, the Lattins don't want that to happen, and so Hooked Animal Rescue likely not going to do it.
Okay.
And so, and that's fine. I do have a matter that I would like to address today because I think it affects affects not only the state's preparation, it will affect Mr. Cover's preparation, and it also will affect the length of the trial. The state has subpoenaed in this case no less than about over a dozen law enforcement officers in this matter, because the length of time involved in the charge is about 2 years, and there were complaints over that lengthy period of time. And the charge would cover those, some of those complaints would be testified to by these law enforcement officers. However, the majority of those, the main reason why those are relevant is because they go to inform Deputy Nastansky's further investigation into this matter in June of this year. We could, since we've subpoenaed them, have them all wait outside for however long this trial takes and trot them all in to have them testify about what they did in their individual calls on each one of those incidents. However, the state really doesn't want to do that. There are other ways to accomplish that, which are within the rules of evidence to allow Ms. Deputy Nastansky, for the most part, to testify about her knowledge of this case based on her reading and her investigation into past complaints against the Lattins. The issue comes up, however, the clear issue there is that Deputy Nastansky would be discussing or talking about how that affected her mindset in this investigation based on what she read, which would be determined to be hearsay. The objection would be from the defense would be hearsay. However, I believe that under the rules of evidence, it's relevant under a state of mind, it's relevant under a number of other things of Deputy Nastansky as she went through her investigation. The other potential way to get that before the court, or at least part of it before the court, would be to actually have the business records themselves entered into evidence as the records of the calls that are kept in the sheriff department records as business records and put them in that way. That itself has some issues, not the least of which would be U.S. v. Crawford, or state v. whatever the Crawford case is, the Supreme Court case in Crawford, which would be testimonial hearsay. But the state would propose that to resolve that issue, that there will be a limiting instruction regarding that particular use of that particular information, or that we just let Deputy Ms. Dancy testify about it in terms of how it fed into her investigation, how her thought processes as she investigated this case, and what that meant to her, and how it caused her to do different things, which is not hearsay at that point. It's state of mind. So I wanted to bring that to the court here because if depending on what the indication the court gives me today, I'm not asking for a ruling at this point, or unless you want to, of course, for Mr. Cover, but I'm going to have to bring 12 law enforcement officers into this trial, and will significantly elongate the trial for information that is both relevant and important, and it also, but it is not necessarily, does not necessarily need to be done in that way. So I'd like to put that out there today because we are at this point, a couple of weeks, or not quite 2 weeks before the trial, and I wanted to get some sense of the court on which way you would like me to go with that.
Okay. Let me hear from Mr. Cover first, and then, yeah, Mr. Cover.
Your Honor, we have questions about that approach simply because we have questions about the admissibility of all those complaints. Our position is that Mr. Licker's going to be coming with what we describe as propensity evidence. So we would ask the court to defer on any ruling, but I would be more than happy to take a look at what Mr. Licker is suggesting be admissible and maybe work it out some other way, since we're going to be discussing the vet inspection upcoming. Thank you, Your Honor.
Well, here's the thing. Of course, I have an interest in, just as typically, I know you all know this, but maybe people in the courtroom don't, but maybe about 95% of the cases in district court are one day, maybe even higher than that. This case is not going to be one day. And so, just in terms of judicial economy and court time and staff time and things of that sort, the court has an interest in making this run as efficiently as possible. But at the same time, Mr. Cover's entitled to not agree to shortcuts, and that's my word. No one's else is saying that. And so, I guess I would encourage counsel to work something out, perhaps come to some sort of agreement as to what be admissible or what's not. But if not, then I'll probably just have to rule on it. If you're making, I can't, I can't just say, well, yeah, I think I might do this or might do that without, it hasn't been briefed, obviously. And
That's
all
fine.
that, so.
I just wanted to highlight it to the court.
Okay.
The officers are subpoenaed. The ones that will be here,
Right.
and my intention is to put Deputy Stansky on the stand and have her testify this as part of her state of mind, and in a non-hearsay matter. If we get an objection to that is sustained, I will trot in every law enforcement officer that is required. I don't want to do that. I don't think I will have to do that. But I just want to let you know that issue is looming large.
Thank you. And again, just not without knowing more about it, I'm not prepared to rule in this time.
I did not anticipate that you would go. I just wanted to raise the issue to the court so you understood what was happening.
Thank you for letting me know that. And again, to the extent possible, I would encourage counsel to work with each other, maybe, to come to some agreement about what is or isn't admissible or not. That would streamline things considerably. And we're going to be back here a week from today for confirmation. All that can be.
There are several motions
at that time.
Yeah, there are several motions remaining outstanding.
And so, yeah.
Okay, very well.
And then you mentioned motions in limine. Last thing I say, are all those filed? Those are filed.
Yes, Your Honor.
Yep. We will deal with those, and we'll have confirmation of that at 3 o'clock.
I believe so.
Yeah, at 3 o'clock, and then we'll see where we're at. Motion limine. We may have to, start the trial. Earmark the first half day for motions, depending on how far we get on the confirmation hearing with regard to motions. And with that, that'll be it for today, and then we'll be back here a week from today.
Very well.
Thank you, court.